Good morning. Our first case is State versus Borlase, and we'll hear from the appellant.
May it please the court, my name is Lisa Miles. I represent Tristan Borlase, and I would like to reserve 5 minutes of my time for rebuttal. Now, the facts in this case are not in dispute. 17-year-old Tristan was sentenced to 2 consecutive sentences of life without parole for the stabbing deaths of his parents, much of which was caught on video surveillance camera outside the house that he had helped install. 2 judges below affirmed the trial court sentencing order. The dissent noted deficiencies in the sentencing order and would have remanded for a new sentencing hearing, and the dissent is correct. It's now well established that the 8th Amendment prohibits sentencing a juvenile to life without parole unless that juvenile is permanently corrupt, and that a juvenile whose crime is the result of transient immaturity cannot be sentenced to life without parole, no matter how heinous the crime. Now, in order to make that determination, was this a crime of permanent corruption or a crime of immaturity, the Constitution requires the sentencer to consider all relevant mitigating evidence. And under North Carolina law, the court has a duty to find a mitigating factor where the evidence is uncontradicted, substantial, and manifestly credible. Now, it was in those 2 respects that the sentencing order was deficient: failure to consider all the mitigating evidence and failure to find a mitigating factor that was uncontradicted and credible. Now, our legislature has enacted a statute in order to help sentencing judges comply with the mandates of Miller versus Alabama, that there be discretion in sentencing juveniles who've been convicted of murder. General Statute 15A 1340 19B sets out the procedure as well as a list of possible mitigating factors. Now, this list is not exhaustive, as subsection C9 also allows for consideration of any other mitigating factors or circumstances. In this case, the trial court complied with the procedural requirements of the statute, but fell short of the constitutional requirements of Miller. And how do we know this? From looking at the order itself. In reading the order, you would never know the actual nature of the Borlase family at the time of these offenses and its impact on Tristan. The first 12 paragraphs of the order recount the day of the offenses themselves, and Tristan's conduct immediately afterward in great detail. 12 paragraphs devoted to a few horrifying hours of Tristan's life. But the years and months leading up to the offenses don't show a permanently corrupt person, but a gifted kid who was trying to navigate a chaotic period of time with a mother he believed he could not please. Now, before this family moved to Deep Gap, North Carolina, where the crime occurred, this once large, intact family lived in a nice home in Mooresville where Tristan had spent, I think, from age 13 to 17. Tristan was an honor student. He was a gifted athlete. The year before he was set to graduate, the family was fractured. He and his dad were living in Mooresville in a 2-bedroom apartment, and his mom and younger siblings were living in Deep Gap. His 3 older sisters were already out of the house at this point. The home that mom and the younger siblings were living in Deep Gap was a 2-story utility shed that was being converted to a home. Now, also during this time leading up, 2 of the siblings had been removed from the family due to anger and violence issues. One was sent into therapeutic foster care, and another was sent to a boarding school for children with behavioral issues. Also during all this time, Tristan and his dad are traveling to Deep Gap every weekend to work on making this 2-story shed into a home and to install the security cameras outside. Now, it was clear to professionals that Tristan was, in fact, being negatively impacted during this challenging period of time. Dr. Jim Hilke put it simply that the offense behavior was influenced by Mr. Borlase's conflicted relationship with his mother. Tristan's group leader at church, Cindy Wilkerson, who's a licensed foster parent, she has her master's in education. She had just about completed her MA in pastoral counseling. She elaborated. She said, "He is a beautiful boy with a kind heart and so many talents who showed multiple signs of suicide risk: depression, sense of hopelessness, despair, withdrawal, isolation, worthlessness, saw no way out, fatigue, confusion, and talked about how broken he felt. He was at risk for suicide and needed family intervention." So by the time he's living full-time in Deep Gap, he had completed his junior year in Mooresville, then they moved to Deep Gap, and he begins his senior year in high school at Watauga. This former honor student was at risk of not even graduating. He was falling asleep in class, he was not turning in assignments, he was vaping, he was smoking, he was sexually promiscuous. None of these realities were considered by the trial court. Instead, the sentencing order essentially erased all of the struggles that were uncontradicted in the record, thereby eliminating critical aspects of Tristan's background from consideration for purposes of sentencing. The sentencing court notes only that Tristan's parents were, quote, loving, nurturing, and caring. And that is true in the very general sense. Even Tristan said as much. That's not been disputed. But the specifics of the family life, the day-to-day life during this period of time, told a much richer, fuller, truer story. The sentencing order goes through and carefully lists every one of the statutory mitigating factors, but then just as carefully tailored the evidence to avoid any consideration that Tristan is not permanently corrupt and that he may be rehabilitated. This is especially evident in its failure to find credible evidence of familial pressure. As the dissent points out, there was considerable, uncontradicted evidence of family conflict and dysfunction. The trial court reduced the evidence of family pressures to, and I quote, "the taking of privileges and interactive discussions," and that doesn't come close to what was really going on. Tristan and his siblings would be summoned to they called it the nest. They got summoned to the nest in the middle of the night for hours to be lectured. This did not come just from Tristan. This was corroborated by one of his siblings. His mother screaming at Tristan's art objects in the home because she believed them to be demonic. Tristan having to sleep in the goat pen or his car because of the chaotic living arrangements. Tristan being sent to a week-long church camp with no clothes and no toiletries as punishment. The major family conflicts, very real conflicts, when two of the adoptive siblings were ultimately removed from the home. And Tristan feeling like he could do nothing right for his mother, that he had gotten to the point he just wanted to make it through the day. Now, as further evidence of the trial court's refusal to consider uncontradicted evidence of mitigating factors, the trial court specifically stated that it had considered factors listed in 15A 1340.16E. That's the structured sentencing mitigating factors. And found that none applied, none. Not even finding that factor E8, that the relationship between him and his mother was otherwise extending, or E11, that he voluntarily acknowledged wrongdoing to a law enforcement officer at the early stage of the criminal process. He was arrested and confessed at length on video. failed to find factor E12, that he had been a person of good character or had a good reputation in his community. I mean, even his grandfather, Gary Borlase, said Tristan was always a sweet and kind child, but changed the year before his arrest. None of the evidence of those factors was considered, none of the evidence of that was contradicted. And the court said none of them applied. And this is directly contrary to the constitutional requirement to consider all mitigating evidence. The trial court simply didn't comply with the Eighth Amendment requirements of Miller when it checked off all the boxes in the statute, named all the statutory mitigating factors, click, 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 and then at the bottom said this person's permanently incorrigible. That didn't comply with Miller. Instead, what had happened, the trial judge, just like the prosecutor, was laser focused on the shocking, truly shocking and brutal nature of these crimes, and that's not supposed to be the focus. In fact, at the sentencing, at the close of the sentencing evidence, when the prosecutor was making his argument, he never argued that Tristan was incorrigible, that he was permanently corrupt. All he argued was that the loss of these two people, which was very great to this family and very great to the community, the loss of those two people outweighed all of any mitigation that Tristan could have presented. And that is absolutely not how this is supposed to work. That's more like a capital sentencing proceeding, where you're weighing aggravating factors against mitigating factors and determining which weighs more, which carries more weight. That's not what the focus is here. The focus is here, is this a child who is never, ever going to be rehabilitated?
So what do we make of Miller when it says we consider, or trial court should consider, whether the crime reflects irreparable corruption?
Right, exactly. Does the crime reflect irreparable corruption? So how did this crime happen? It's not how bad the crime is. By the time somebody's facing a sentence of life without parole, they have committed a horrifying crime already. So that's already assumed. So does the crime reflect irreparable corruption? So was this crime committed by a juvenile who we have been seeing all through his life that no amount of correction is going to help him? He's been nailing cats to trees. He's been in juvenile court. He has been in juvenile court counseling, and no amount of corrective measures are helping this child. That's what we're looking for. We're looking for the arc of this person is damaged now for whatever reason and will remain damaged until his dying day. And Tristan showed none of that. Tristan was the kid we all want. Tristan is the kid we would have wanted our child to hang around. He was that good person up until things just absolutely started falling apart. And that's not the person who's never going to be rehabilitated.
Well,
that's what Miller's talking about.
But what you've said seems to focus on the criminal and not the criminal act.
That's right.
And Miller specifically says we look at the crime and whether the crime. And so to me, there's a disconnect between when the Supreme Court says we focus on an act as opposed to focusing on these other extraneous circumstances.
Well, I can understand the confusion there, but the interesting thing is, if you take a look at Miller and Montgomery and Jones, they don't really talk about the crime. They describe the crime when they're setting up their opinion. It was like, here's the kid, here's the crime that got committed. It was horrifying. They're all horrifying. But the bulk of those opinions, all three of them, they're talking about the kid and what the kid may have been through, why the child is different, why a kid is different from an adult for sentencing purposes. So we have we've got capital punishment available to adults for sentencing purposes, because that adult is fully formed. That's who that adult's going to be. This is a person who still hasn't finished being formed. Something horrifying happened, a period of several months up to, or more than a year of what had been his world is falling apart, and something horrifying happened at the end of that. That's the lens that you see. Does this crime reflect corruption, or does the crime reflect transient immunity?
So
Immaturity, I'm sorry.
in James, we say we focus on the totality of the circumstances.
Right.
If we look at the totality of the circumstances, do we exclude the crime itself?
No, no, the crime happened. The totality of the circumstances is, how did we get here? How did we get here? That's what that's talking about. You don't pretend these people didn't die. I'm not suggesting that. I'm not suggesting this wasn't horrifying. In 33 years, this literally may have been the worst crime I have witnessed. I've done criminal defense my whole career. This was horrifying. But the focus of Miller and the Miller jurisprudence is, how did this crime occur? Is this a permanently corrupt kid who is never, when he's 50, when he's 60, when he's 70 years old, he's never going to be any different? And the evidence just doesn't show that here.
So Miller was dealing with mandatory life imprisonment without parole, correct?
That's right.
And the purpose of Miller is to allow the trial court to consider all the factors that you've just argued,
Yes.
correct?
Yes.
How was that not done here? And how did the trial court not consider? Now, obviously, the trial court did not adopt, but how did the trial court, in its order, not consider, as it was required to do, the various factors?
Well, I think I said what the trial court did was reduce this family to a loving, caring family that Tristan was angry with because they took privileges away. That doesn't capture anything that was really going on in his life. And if you'll notice in the sentencing order,
But the
he
trial court
doesn't talk
the trial
about it.
court is allowed to weigh the evidence as it's presented and ultimately, in her discretion, make a determination what weight to assign, correct?
Exactly, that's exactly right. And that's where things get a little muddied, I think, by the Attorney General. So there's two things going on. You have to consider all the mitigating evidence. That has to be considered. That's Eighth Amendment jurisprudence. You have to look at everything. That's not discretionary. What's discretionary is how much weight to give this. And what's particularly disturbing in this particular order, and the dissent picked up on, is that the trial court said there was no evidence of family pressure in this particular case. So it's not like he
Well, the
considered
trial
it
court
and
is
didn't
talking
weigh
about,
it.
excuse me, ma'am, if I may.
Yes, sir.
The trial court certainly had seen other cases where there was actual pressure from a family for the defendant to commit the crime. Now, that didn't happen here, right?
Well, there's not just one kind of family pressure.
Well, see, what you're describing, though, again, gets into family dynamics that my life experience is there are no perfect families. And certainly there are extremes, but I think what the trial court was looking at, as directed by the U.S. Supreme Court, was, and certainly under the statute, is were there dynamics within the family that push this individual to commit the crimes? Were mom and dad saying, hey, come do this crime with us. Hey, go take this for us. Clearly, that was not the case here. Now,
No.
How much discipline is too much discipline? How strict should families be? Is that really what this sentencing hearing should be about?
This is absolutely not what this sentencing hearing is about. The sentencing hearing was about looking at what Tristan's life had been leading up to the crime, to include his life before things fell apart, and what it did to him. And that was what Dr. Hilke described. That's what not Dr. Wilkinson, but Cindy Wilkinson described, that he was feeling pressures from all quarters. The family had fallen apart, siblings had been removed from the house. The mother is a factor in this, but we're not talking about just, I don't like my discipline. That's what the trial court reduced it to. It didn't look at the whole picture, and it said specifically it wasn't looking at the whole picture because it said there was no evidence of those things, the family pressure. And I understand that Miller was dealing with family pressure of what we consider, particularly in capital sentencing, the normal kind of mitigation, where a child is abused, a child is abandoned, a child is watching his mother do drugs, that sort of family pressure. But I really can't imagine that the Eighth Amendment expects us to take such a narrow view of what family pressure is. What was described in this household would have been challenging even for an adult to deal with. It would have been challenging. An adult would have, knuckled down and gotten through it. But this was wholly disruptive to the only world, the only life that Tristan had ever known. And it was simply wrong not to take that into consideration. Now, had the trial court considered it and maybe decided there wasn't enough weight, he could have said that, but he flat out didn't consider it. And furthermore, the bottom line for a Miller consideration is this child permanently corrupt? Will this child never be rehabilitated?
And is that a required finding?
I'm sorry?
Is that a required finding?
He doesn't have to make a specific finding of permanent corruption. He did under North Carolina law, he does have to make that finding, and he did. The court found he was permanently corrupt. The evidence just didn't support that. That's not what, this isn't a matter of there being conflicting evidence and, oh, my evidence shows this and your evidence shows that. This was the whole body of evidence. If you looked at that whole picture, you are seeing that this is not a kid who is going to be never going to be rehabilitated, that he is permanently corrupt. Based on the uncontradicted evidence, this court should remand this case back to Superior Court for an entry of an order sentencing Tristan to life with parole, or remand to the lower court for a full and fair appellate review that comports with Miller. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court, my name is Heidi Williams. I'm here from the North Carolina Department of Justice, and I represent the state in this matter. In 2019, defendant, who was only 1 month shy of his 18th birthday, killed his parents, Jeff and Tanya Borlase, at their home in Deep Gap, North Carolina, by stabbing them repeatedly in the torsos and strangling Tanya to the point of causing hemorrhages in her eyes and fracturing the cartilage in her neck. The state today asks this court to affirm defendant's consecutive sentences of life imprisonment without the possibility of parole for the brutal and premeditated murders of his parents, because the trial court, in exercising its discretion to impose these sentences, complied with all state and federal constitutional requirements, as well as North Carolina's juvenile statutory sentencing scheme. At the outset, this is an appeal that is based on a dissenting opinion from the Court of Appeals. Below, the dissenting judge, Judge Arrowwood, determined that there were 4 errors in what the trial court did here that warranted a remand for resentencing. First, that the court failed to establish whether defendant's age had mitigating value. Second, improperly assigned no mitigating value to the familial or peer pressure factor. 3, improperly assigned no mitigating value to the immaturity factor. And 4, violated defendant's constitutional rights because he refused as a matter of law to consider relevant mitigating evidence. All of these positions taken by the dissent were refuted by the majority in the Court of Appeals, and the state submits that the majority provided an appropriate analysis. First, the trial court did not abuse its discretion here in assigning no notable mitigating weight to the factor of age. In its sentencing order, the trial court found that defendant was 17 years and 11 months old on the date of the offense, and further found that defendant reached the age of adulthood only 1 month after committing these crimes. When considering this finding in context, it is evident and easily implied that the trial court's finding that the court assigned no notable mitigating weight to this factor was supported. Specifically, because the court stated, after noting defendant's age, that he reached the age of majority only 1 month after committing these homicides. This was sufficient. The trial court's finding here was sufficient on the factor of mitigation. In addition, I just want to back up for a moment. I think it's important to recall that as we are reviewing the manner in which the trial court weighed the mitigating factors here, this court should review those findings for an abuse of discretion. So in non-Miller statutory sentencing contexts, this court has repeatedly held that the manner in which a trial court weighs mitigating factors at sentencing is reviewed for an abuse of discretion. And the Court of Appeals, in specifically the Miller resentencing context, has applied that same discretionary standard of review in reviewing trial courts' finding, or in reviewing how a trial court weighs mitigating factors under the statutory sentencing scheme. It's a deferential standard of review.
I do have a question for you about the standard of review, because it seems to me there's a distinction between the review of how the factors are weighed versus whether or not the factors are taken into account in the first place. And isn't it our precedent that when the evidence is uncontradicted and manifestly credible, the court has to take that into account? So the court, it's not like they can just, certainly for statutory mitigating factors, that the court has discretion about whether or not to take them into account. The discretion is then how they are weighed with the other factors.
So a couple points in response to that, Justice Rolls. One is that I agree with you in that the post-Miller juvenile statutory sentencing scheme makes clear that a trial court must consider any evidence of mitigation that the defendant puts before the court.
So we do have the responsibility to evaluate whether or not the court has done that.
Whether or not the court has, yes, I think that's accurate. Now, whether or not the standard in assessing was the trial court required to credit the evidence and to find that it had mitigating value in the context of that statutory analysis is a slightly different question. And this court has held in cases under the Fair Sentencing Act, cases like State versus Spears, which the defendant cites on appeal, that the standard is the court has to accept the evidence if it is uncontradicted. I believe it's uncontradicted and manifestly credible evidence. The court has to basically credit that evidence and give it some kind of mitigating value. Now, this court has not applied that standard yet in the Miller resentencing context. So it could, but so far this court's case law on that standard is from, the cases cited by defendant were from when the Fair Sentencing Act was still in place.
Right, but certainly here the defendant is arguing that we should at a minimum apply that standard.
That's correct.
Right, and here their argument is that there was credible, uncontradicted evidence of some of the factors that then meant the trial court needed to take them into consideration.
That's correct, that is what the defendant's argument is, Your Honor, and the state's response is simply that the trial court did consider all of the evidence, it just didn't find it credible. And in fact,
so like when the court says there's no, on the family pressure, the court says there's no credible evidence of this mitigating factor, are we to take that to mean that the court concluded that the testimony about the mother taking them to the nest in the middle of the night and lecturing them like some sort of religious fanatic in like a Hollywood, horror movie, that never happened? Or is it that the court just said that has happened, I just don't think that's credible evidence of any kind of family pressure that's a factor under Miller? Which of those two was going on here?
So, Your Honor, I can't get inside the sentencing judge's mind to know exactly what he said, and nor do I think the court was required to articulate to the fullest extent possible every thought he had in considering this information. I think what the statute required is that the court consider any mitigating evidence, and the defendant offers no proof that the trial court did not at least consider the evidence that he put on at the resentencing hearing, and then has to make findings of fact about the absence or presence of those mitigating factors.
So the taking them up to the nest evidence, you don't think, could that never be factors that you would consider in mitigation? Because if it is, wouldn't there, if you thought, the court thought that was testimony was true, there would be some evidence. It's just the court didn't find it persuasive to find that that mitigating factor influenced the sentence, right?
So 2 points in response, Justice Dietz. The first is that this evidence about his parents taking him to the nest for some kind of disciplinary discussions. The state's position is first that kind of disciplinary decision by a parent isn't what the familial or peer pressure factor is even aimed at addressing. Based on Roper and this U.S. Supreme Court's decision in Miller, both of those opinions made clear that familial or peer pressure deals with whether or not a juvenile was unable to extricate him or herself from a criminogenic setting. So an environment where his peers or his family was prompting him to commit crimes. And there's just no way you can construe reasonably a disciplinary decision that is made by parents as being that.
But what if, I mean, isn't the problem here that it's a different type of familial pressure? Because the argument would be, and this gets back to Justice Berger's point about you have to focus on the crime, is that the defendant's mother arguably is some sort of religious fanatic, ruining his life. He snaps. Who does he kill? Her. And so it's tied directly to the crime in a way that you may say, well, given that family pressure, this juvenile is subject to rehabilitation, is not incorrigible, because this is not someone who's going to become a serial killer and kill other people. You can trace a direct line from this sort of destruction of his mental health and things from what his parents did to him to the crime. And to me, it just seems like the court did not want to think about any of that, because you might then acknowledge some mitigating factor, and it's a much cleaner sentencing for a juvenile to life without parole if you just say there are no mitigating factors whatsoever, and that's the end of the case.
So, Your Honor, I think in response to that, I think there was substantial evidence in the record that discredited defendant's kind of claims about the scope of his discipline with his mother. So all of the information that defendant is citing here that claiming the trial court did not even consider was evidence that defendant gave to Dr. Hilke during his discussions with Dr. Hilke, but there was other evidence on the record that supported that this was not a kind of family life that was just seeped in dysfunction and overly harsh disciplinary tactics. So, for example, defendant's sister Taylor, she described her parents as loving, compassionate, supportive. She explained that when she would get in trouble during high school, there was never any fear of physical violence or physical discipline. Instead, her parents would sit down and talk to the children. And Taylor described that sometimes these conversations were long, she found them annoying, but then described that after she left the house, she really appreciated the effort her parents took to sit down with them to have these discussions about behavior, about school. So that evidence from his sister was in the record. Jennifer Sharpley also described Tanya and Jeff as, quote, the most ideal and involved parents a teacher could ask for, and responded absolutely not when asked whether she ever observed Jeff and Tanya inappropriately disciplining their children.
And if I might interrupt, was there not an incident of discipline that involved sending the defendant to a camp with virtually nothing, no toiletries or whatever? Was that uncontroverted? And can you help me get comfortable?
So,
well,
Your
not
Honor,
comfortable, but could figure out how to make that work in this situation.
Yes, so, Your Honor, there was evidence in the record that there was an instance when Tristan had gotten in trouble for some of his behavior, and as punishment, his mother, he was going on a church, an extended church weekend trip, and his mother sent him on the trip and did not allow him to bring clothes or other toiletries. And so another leader who was with him on the trip went and bought him some clothes and toiletries.
Would that not be evidence of extreme discipline?
I think it would depend on how,
Perhaps the alternative was to make him stay at home, but to send him away with nothing in his bag, or even a bag at all.
yeah, I mean, Your Honor, that's, one of these issues is that a disciplinary choice that I would have made as a parent? Perhaps not. Was the trial court, however, required to find the mitigating factor under the statute of familial or peer pressure, and to find that somehow the murder of these two individuals should be mitigated because defendant's mother once punished him by sending him to a church camp without a change of clothes? Those are two different inquiries. And again, when we're looking at how the trial judge here decided to weigh the mitigating factor of familial or peer pressure, again, assuming that this factor even encompasses a parent's disciplinary choices, because it may be that this factor, the state's position is that this factor doesn't address those kinds of decisions at all.
But wasn't there was some corroborating testimony or evidence from other siblings in the family about the nest and about, and then his ex-girlfriend testified that she was on the phone with him and heard his mother screaming at him. So again, some corroborating testimony. And then wasn't there also testimony that he fell asleep at school and wasn't concentrating in his classes, which again is if you are being woken up in the middle of the night for 3 hours, 3 or 4 times a week, it certainly is interrupting your sleep and your ability to concentrate at school. So it seems like there was evidence in the record corroborating his own statements about how, I think there's a line between discipline and abuse, right? And there was certainly some corroborating evidence here.
Your Honor, I don't disagree that there was some evidence in the record that supports that the parents here used disciplinary tactics that maybe you or I would not choose to use on our children. But the question here is not whether in your personal discretion this crossed the line from being appropriate discipline to being some kind of abuse. The question is, did the trial judge here abuse his discretion by not finding that evidence credible in light of other evidence that existed in the record from defendant's teachers, from defendant's siblings, that supported that these parents were loving, they were caring, they provided a safe home for Tristan?
But I think the argument here is not that he heard that evidence and weighed it in the calculus, but that he didn't weigh it in the calculus. He didn't make a finding that showed he took that evidence into account.
Your Honor, there's nothing in the post-Miller statutory sentencing scheme that, again, requires the trial judge to describe in detail in writing every aspect of his or her thought process.
Right, but then if your argument to us is the evidence was presented, the trial judge doesn't have to indicate that he's weighing it or not weighing it, then how are we ever to determine whether or not the statutory mandate that if there's credible evidence it must be taken into account, how are we ever to determine whether that's been complied with?
Your Honor, the trial judge would certainly have to make a sufficient amount of findings as to those mitigating factors to somehow accommodate appellate review. But here, the court did that, right? It described under familial and peer pressure. It found that defendant grew up in a safe and loving environment where he had supportive parents who encouraged him to do well in school. And essentially, if this court were to overturn what the trial judge did here, defendant is asking this court to reweigh this evidence on its own. So to step into the shoes of the sentencing court who observed the guilt phase of these proceedings for multiple weeks before the sentencing hearing and then considered in person all of the testimony from defendant, from his siblings, and found that based on observing those trial court proceedings and sentencing where defendant was again allowed to speak, that his evidence suggesting that how his parents behaved was inappropriate or went so far that it should be cast in a mitigating light to somehow reduce the punishment for his murder of his parents. The court said that evidence was not sufficient and did not find it credible in light of the other evidence that was before it in the record.
It seems to me clearly the point of that evidence is not in any sense to blame somebody else for the crime. The point is to evaluate this juvenile to determine whether or not he's permanently incorrigible or whether the crime occurred because of his immaturity, because of factors in his environment, that if you take those factors away, he wouldn't reoffend. Isn't that the point of the evidence, that we're evaluating whether he's incorrigible or not?
Yes, Your Honor. I mean, that is kind of the ultimate inquiry and why the court is required to consider these mitigating factors.
I have a question, a follow-up, and I guess it's more legal than factual. Am I correct that it's the state's position the familial factors relate in a narrow fashion just to an environment where someone is being coerced, put up to whatever, to commit crimes, sell drugs, shoplift, or whatever? If this court found that it was broader than that, instead a more in line with some of the questions that are being asked now, how should we proceed? What's your view there?
So, Your Honor, I think that if the court finds that this factor is broader and can consider any kind of dysfunction in a family environment that is evidence of which is submitted by the defendant at resentencing, I think then this court is in a position to assess whether, well, did the trial court abuse its discretion in the way it weighed the evidence of mitigation here. And again, the state's position, even assuming that this factor is broader than just an inability of a defendant to extricate him or herself from a criminogenic setting, the evidence here, you had evidence on one side that supported these are ideal parents who love their children, provide a stable home, go out of their way to try to accommodate their children's needs and desires. You have testimony that supports that view of the parents on one side. And then you have testimony, alternative testimony from Dr. Hilke based on interviews he conducted with defendant, where defendant describes, well, my mom took me to the nest in the middle of the night and we had these long discussions. And yes, you could look at that and say, okay, that is perhaps not an ideal parenting or disciplinary tactic. But again, it is not the role of this court on appeal to try to reweigh that evidence and which evidence did the court find more credible. And again, I would repeat to the court that the sentencing judge here heard testimony from Dr. Hilke, heard testimony from defendant, heard testimony from defendant's siblings, all describing kind of what the feel or the environment of this home life was, and found the testimony that this was a safe, stable, appropriate home that should not give mitigating weight to the punishment the defendant may receive for these crimes. It was the trial judge's role as the sentencer to make those kinds of credibility determinations, to weigh the evidence how it saw fit. And I think to reach the conclusion that defendant asked you to basically say, well, the manner in which the trial judge weighed the evidence here was inappropriate, asks this court to usurp the discretion that the sentencing judge had.
In finding 15H, the trial court states that while a defendant may have genuinely disagreed with the form of discipline, parenthetical, taking of privileges and interactive discussions, he admits that it was in his best interest. Why couldn't the parenthetical be read as the trial court considering all of this evidence, the nest? It doesn't have date and time of when these discussions took place or when privileges were taken away, when the camp occurred. But why isn't the parenthetical enough to show that the trial court considered the evidence?
I think it is enough, Your Honor. And I think that the record here supports that the trial judge, there's nothing that defendant can point to say the trial court refused as a matter of law to consider some evidence that I put in front of the court. I would also remind the court that there's typically when reviewing these kinds of decisions, there's a presumption of regularity, where in the absence of evidence showing that the judge refused as a matter of law or did not consider something that the defendant put before the court, that the court acted appropriately and considered the information it was supposed to consider. And here, again, defendant cannot point to any kind of fact in the record that supports that the trial judge refused to consider his evidence. Instead, the record only supports that the trial judge refused to find his evidence credible or to conclude that it outweighed the other evidence that supported that no mitigating weight should be assigned to this factor.
So if we believe that the parenthetical is enough to show that the trial court considered the evidence, what do we make of the last sentence in that finding, that there's no credible evidence to support a finding of mitigation?
Your Honor, I think you can take from that sentence that the judge didn't find credible the defendant's descriptions of, I suppose, kind of the severe nature of the discipline that he claimed he was receiving. Or that it found, it could also be that factor. It could be that the trial judge, when using the word credible, just found that the information that was in front of the court, that it didn't find any evidence the defendant presented outweighed the evidence supporting that this was not a factor that should be given mitigating weight.
And is that permissible by the trial court to say that even though I've heard this evidence, I'm going to find a particular way and it doesn't rise to the level of tipping the scales in mitigation?
Absolutely, Your Honor. So the court has authority under the statutory sentencing scheme to find the presence or absence of these mitigating factors. Just because a defendant presents evidence does not require that the sentencing judge to accept that evidence or to find it credible. Again, this was within the trial court's discretion sitting in a sentencing position. I would also point this court to Eddings versus Oklahoma, which goes to this issue, Justice Berger, and Judge Arrowwood, in dissent in the Court of Appeals, said, well, basically what the trial judge did here was a violation of Eddings versus Oklahoma, where a judge refused to consider evidence that may support a mitigating factor in the capital sentencing context. However, in Jones versus Mississippi, in footnote 7, the United States Supreme Court explained that, by analogy to Eddings, if a sentencer considered life without parole for a murderer who was under 18 and expressly refused as a matter of law to consider the defendant's youth, as opposed to, for example, deeming the defendant's youth to be outweighed by other factors or deeming the defendant's youth to be an insufficient reason to support a lesser sentence under the facts of the case, then the defendant might be able to assert some kind of Eighth Amendment claim under the U.S. Supreme Court precedent. So the court here, so in light of Eddings, the question is not, can the court credit or discredit this evidence? The court certainly can do that. The question, in order to show the kind of constitutional error that the defendant is asserting occurred here, he would have to show that the trial judge flat out refused as a matter of law to consider his mitigating evidence, not that the court improperly weighed the evidence, which is what he is arguing occurred here. Unless the court has other questions, the state would urge this court to affirm defendant's sentences of life without parole.
Thank you, counsel. Rebuttal.
Couple points. Here is some of the uncontradicted evidence that has to be discredited for there not to be credible evidence of family pressure. Messeret described being called to the nest for lectures. That wasn't just Tristan. Messeret described the same thing. A formerly intact upper middle class family living in I think Dr. Hilke described it as a $500,000 house in Mooresville, now living in two separate towns, Dad and Tristan living in an apartment, rest of the family living in a utility shed being converted into a home. That was never discredited. That was never called into question. Two siblings being removed from the home due to their violence and behavioral issues. That was never questioned. That was never discredited. As Your Honor pointed out, Tristan being sent to camp for a week with just the clothes on his back as punishment. That didn't come from Tristan. That came from Cindy Wilkerson. And then Cindy Wilkerson's report of Tristan showing signs of suicide risk, hopelessness, and despair in the year prior to this crime. That was not disputed. The state never questioned that. The former girlfriend's report that Tristan thought he couldn't please his mom and ended up just trying to make it through the day. Nobody disputed that. Tristan didn't say that. That was the ex-girlfriend's observations. The teachers reporting in Watauga that he began school normally, that he was well-liked, that he was doing fine in class, only to begin falling asleep, not turning in assignments, and coming close not to graduating. Nobody disputed that. So all of that evidence has to be deemed not credible for the trial court's finding that there was no credible evidence presented of family pressure.
Well, why isn't that considered in the finding of depression in, 15G? I mean, that sounds like depression, and what Dr. Hilke said, I think, is your client had depression that was exacerbated by his marijuana use.
Yes, so depression was found.
So, I mean, what you're describing seems like what the trial court found in G, perhaps.
Well, let's back up. Let's go back to the top of the list. You know, being summoned to the nest doesn't necessarily go to depression. It certainly could have made him depressed, but other siblings describe that. The family being blown apart and separated, that could make him depressed, but that was still a factor that was happening in that family. Siblings being removed from the house because of violence and anger issues. I mean, just think of the extreme violence and anger issues that had to be happening in that house where Tristan was living for siblings to be removed, and one had to go to therapeutic foster care. I mean, that's intense. That's not just here, let's give this to a foster family. That's going into a specially structured foster situation designed for somebody with extreme behavioral issues.
And
So it's not-
those were 2 of the 4 adopted children, right?
That was with 2 of the 4, yes, sir.
So,
Actually,
we really don't know the dynamic created in this family by its decision, and we don't know whether it's mom and dad or mom and dad and their 4 biological children, to expand their family in this way. We don't know the details of any of the relationships that may or may not have occurred between the biological or adopted children. Do you really think that our duty as an appellate court is to dig into this family and try to figure out, isn't that the trial court's responsibility?
yes, and he didn't do it. The evidence was there. The evidence was uncontradicted. The state never contradicted any of it. And then Dr. Hilke said this is what was going on with him, and not just from Tristan's reports. Dr. Hilke said this is what was going on. This impacted him deeply. And
The trial court found that in G, the court finds mitigating value as it relates to his depression. I mean, I understand your argument that it could relate to the familiar peer pressure, but it seems like the court considered it and found in G that even though he had depression that was exacerbated by his marijuana use, that it was that it had mitigating value.
that's correct. I'm sorry, Justice Berger, I'm afraid we might be going around in circles. I mean, yes, he did find that there was depression. I'm not disputing that. All of these other factors, all of this other stuff that was happening was real. Nobody said it wasn't happening. It happened in the family. It created family pressure. And I think to limit family pressure to just, here, I'm living in a drug house and my dad beats me up every night, I don't think that's going to pass constitutional muster under the 8th Amendment. The 8th Amendment doesn't limit the consideration of any mitigating factors. And this was a real thing. Hilke, Dr. Jim Hilke said this was a real thing. And Jim Hilke is one of the most respected, experienced psychological experts and practiced in our state courts for over 40 years. And frankly, this particular evaluation is probably one of the most thorough I have ever seen. He didn't get this information from Tristan. Yes, he spent 25 hours talking to Tristan. He also administered 9 different psychological instruments to him, 2 of which were for malingering. He found there was no malingering. He gave him the WACE, the Milan Clinical Multi-Axial Inventory, Personality Assessment Inventory, the MMPI, the Rorschach.
I'm sorry to interrupt you, but, so you've gone through this sort of litany of things that aren't specifically mentioned in the trial court's order, and I guess my question is, if they're not specifically mentioned in the order, is our assumption that the trial court, you seem to draw from that the conclusion that the trial court didn't consider them. Is that what we should conclude, or should we conclude that it considered them but just didn't give them the weight that you think they ought to have?
That's a very good question, and again, I think that's where things start to get a little confusing.
But what's
or
our
waiting or
presumption?
refining. Right, so with respect to familial pressure, that's answered in the order. The trial court said there is no credible evidence of familial pressure, and yet there's a huge body of familial pressure that was not disputed. So we know he didn't consider it. We absolutely know that, because he says the list of the short list that I just went through, he said there was no credible evidence of that.
Thank you,
But-
counsel. Your time's
Thank you very
expired.
much, Your Honors.